name is Elizabeth Harris. In the Williamson County Juvenile Court System, I am also known as the mother of J.H., the plaintiff in a pending civil rights lawsuit. I am here today not to talk about the civil rights lawsuit pending against Williamson County, but about the devastating effect of the juvenile court system and the integral role played by Judge Sharon Guffee. It is my belief and opinion that my son is a victim of assault directly related to the mismanagement of the Williamson County Juvenile Court System by Judge Guffee. In 2013, my son was suffering from an autoimmune disorder that manifested in a variety of neuropsychiatric symptoms. There is no dispute that his behavior was impulsive, disorderly, and defiant, but he was not a criminal. Over the prior 2 years, I had sought desperately, as a parent, to find the source of his episodic apparent behavior. I sought medical and mental health relief, but continued to struggle with a real answer. Finally, I believed that as a responsible parent, I should engage the juvenile court system. I was told that juvenile court was rehabilitative, and I believed that they would be able to engage resources that were otherwise unavailable to my family. This was the biggest mistake of my life. My son's experience in the detention center was abusive, and the next 6 months of our lives would be a living hell. Instead of facilitating my attempts to admit my son into a brain rehabilitation center in Illinois, Judge Guffee put a tether on me, ordering that I had to get him admitted into the facility on that very day she released him, or I would go to jail. An impossible task, since the facility in Carbondale was 3 hours away. Nevertheless, I tried. If I did not make an attempt to get medical treatment, I felt that I was sentencing my son to solitary confinement, because this had been Judge Guffee's remedy of choice. By October 2013, my son had already spent 8 days there in the Williamson County Detention Center in solitary. Over the prior 3 months, I had seen him deteriorate even more, and yet I was unable to get him admitted to the medical facility. When I told my son that he had to be returned to detention, he believed that he would again be incarcerated in solitary confinement. I could see the fear in his face and hear the terror in his voice, and he's begged me not to take him back. So I kept him away while I continually worked on admission. On November 14th, Judge Guffee called me and screamed at me that I had to immediately return my son to jail, even after I tried to explain that we were still working on the admission. The following day, I returned my 14-year-old son to the Williamson County Juvenile Detention Center. I had no idea how bad it would get. Within 6 days, Judge Guffee managed to have me arrested, which was later dismissed, and then she restricted my contact with my medically fragile child to 30 minutes a week. Also, since my son had been in homebound through the Board of Education, he was now cut off from all schooling. My son was then accused of assaulting and threatening other boys in the detention center. Instead of giving him a hearing, they isolated him in a concrete cell that, as he described, was not larger than our bathroom. He has since described this experience as the abject loneliness as the darkest time in his life. Much of what occurred in juvenile detention I am forbidden to tell you, because Judge Guffee and her staff shut down all contact with my son, left him in solitary confinement, and did not get him mental health treatment or trauma intervention. Judge Guffee's efforts to undermine me did not stop. She denied me requests to release him for his follow-up appointment with his neurologist. Before my son was released from detention, the court recommended that he be placed in Hermitage Hall, a facility for sex offenders, and they filed a petition against me claiming I was guilty of medical neglect. When I refused to agree with the allegations in the petition, they threatened to make the charges against me worse, and they did. When I brought my son's psychiatrist to court on January the 6th to again try to explain his complex medical issue, they served me with a petition accusing me of Munchausen's by proxy, a mental health disorder of parents who manufacture diagnoses of their children, and Judge Guffee refused to allow the psychiatrist to testify. The GAL convinced Judge Guffee on January 6th that I should be restrained from talking to any of my son's medical providers, and added the proviso that I could not say a bad word about the GAL without her permission. My son was in a living nightmare. He was trying to recover from a neurological disorder, an assault that had taken place in the detention center while he was there, and losing his mother, the one who had provided his care. What has been the damage to my son? In May of 2015, you may recall that a young man sped through downtown Franklin and crashed into a storefront. That was him. My son had left the house one night and was triggered at the sight of the police when this occurred. I am lucky he is alive. As I said at the beginning, I blame Judge Guffee and our mismanagement of the detention center. Had Judge Guffee allowed me the proper time to admit my son for medical treatment, the perpetrator would not have had the opportunity to assault him. Had Judge Guffee properly trained her staff and the management of the facility, my son would not have been placed in solitary confinement. Had Judge Guffee disclosed the personal communication she had with the GAL, my attorney would have been able to assault her pleadings before they caused damage. I believe as commissioners you have an obligation to this community and the families that reside here to ensure the fair treatment of juveniles and their families in times of crisis. I am asking that the commission vote to remove Judge Guffee from the payroll of this county and find a judge who will make this a better place to live.